Good day, everyone. I'm John, your moderator for this webinar on the behalf of the organizer company called Conference Panel. I welcome everyone for today's webinar, which is called HIPAA Ruling and Guidance for 2022. So now I would like to introduce our presenter for today, Mark R Brengelman. So let's come with the speaker's bio. Mark R Brengelman is an experienced attorney in administrative and professionals licensed law, representing a wide variety of professionals, clients, from licensed individual healthcare professionals to licensed healthcare facilities and many others. As a frequent participant in continuing education, Mark has been a presenter for over 30 national and state organizations and private companies. So now I would like to hand over the floor back to our speaker. Over to you, Mr. Mark.
Thank you very much, conference panel, and thank you very much, John, for that excellent introduction, just as I wrote it. Let me give a little bit of introduction about myself before we take a deep dive and otherwise then skim the surface on HIPAA Rulings and Guidance for 2022 on behalf of conference panel. As John stated, I hold degrees in philosophy from Emory University, my law degree from University of Kentucky, and I served out a successful 20-year career with state government. And also I represent parents and kids in confidential child abuse and neglect cases, termination of parental rights, and adoption proceedings. So let's learn about HIPAA for 2022. Based upon the content of this program, we hope we will cover the basics of HIPAA privacy and security, some anticipated changes for the coming year, for this year. I do also include as a goal and content to the program. So this webinar identifies and examines the changing HIPAA landscape under federal law with a broad overview and some highlights of what I think is important for 2022. It's always good to start with the basics of HIPAA privacy and security. So basics of HIPAA security involve the HITECH Act. Former President Barack Obama signed the HITECH law as part of that American Recovery and Reinvestment Act. Let's take a little bit of background about the federal right of privacy for protected health information. Do not forget that HIPAA is in addition to various state law privacy rights. Protected health information is for covered entities. It can even cover independent contractors, as I've said, who are called business associates, even law firms, as I mentioned, if they contain medical records with protected health information. So with regard to cybersecurity and the landscape ahead for that, so it's predicted in 2022 that ransomware attacks will increase. So a key takeaway for 2022 for the cybersecurity landscape is that these risks still can be managed with strong HIPAA compliance. Ransomware attacks succeed because organizations have simply not kept up with the basics of prevention. In early 2021, the Health and Human Services Department published those proposed changes and to revise that content requirement to clarify how patients may exercise their individual rights and making potential changes to the National Institute of Standards and Technology guidelines. Preparing for tomorrow, review and revise your HIPAA risk analysis. Patient access to medical records was spurred on by President Obama signing the 21st Century Cures Act, and the deadline for compliance was last year. There were 8 mandatory categories of clinical notes that were made available to patients, including consultation notes, discharge summaries, histories and physicals, imaging narratives, lab report narratives, pathology report narratives, procedure notes, and progress notes. Those are some of the things that have to be made available to patients in their record. Note how that list is different than some state law requirements for licensed professionals, such as psychologists in my jurisdiction, who by state law are only required to have 6 different things in the patient's psychological record. So 221's proposed rule changes to HIPAA for 2022 also advances a push towards the goal of interoperability. So with regard to what we will move on now to patient access to medical records with a focus on interoperability, what does OpenNotes have to do with patient access to medical records? So what about recent enforcement actions? Let's see on time now. Medical record enforcement actions. Medical record enforcement actions include the case of Dr. Glasser, So data breach and enforcement actions include the case of Excelis Health Plan, which reported a breach of nearly 10 million records back in 2015. Well, let's think here about HIPAA and COVID-19. The Health and Human Services Department has issued guidance relaxing some HIPAA requirements about teleconferencing tools and reiterating HIPAA. Remember, this was temporary. Well, as we conclude, what are best practices, tips, and techniques to prepare for tomorrow? I hope we've covered it all, and we will still have time for questions and answers. We have covered the basics of some HIPAA privacy and security. It always helps to start with the basics. We've discussed anticipated changes for 2022. Interoperability has been reviewed and what it means for 2022. We've talked about the advantages and disadvantages of OpenNotes, electronic health records, and patient access, and how that may or may not jive with what state law requires. State law may be slower to catch up. We've covered a comparison of patient records, patient access to those records under state laws and under HIPAA, and how healthcare is a target by cybercriminals in 2022. We've discussed these best practices, tips, and techniques to prepare for tomorrow. So that ends my presentation. Thank you everyone very much for your patience in hearing me out on the HIPAA changes for 2022. I think this has been I know this has been a very worthwhile use of our time and energy. Look for my other recorded webinars as well as ones upcoming. Take care, everyone, during these turbulent times, and stay safe as always. Over and out.